Today, we're jumping right into a legal puzzle that has kept Indian businesses and lawyers guessing for decades. And it's a puzzle that the Supreme Court has finally, definitively solved.
Okay, so imagine this. You've just been through a long, expensive arbitration process. The arbitrator, the expert you agreed on to settle the dispute, gives their final decision, the award. But as you're reading it, your heart sinks. You see a huge mistake, not just a typo, but a real game-changing error. So what happens now? Can a judge just step in and fix that one mistake? Or does the entire decision get tossed out, forcing you to start the whole painful process all over again? This one question has been at the center of a massive legal fight in India for years.
Well, now we have an answer. This right here, this is the judgment from a Constitution bench of the Supreme Court in the case of Gayatri Balasamy, and it basically settles the debate once and for all. So let's break down exactly what it says and what it means for everyone.
Now, to really get why this was even a debate in the first place, we've got to rewind the clock a little bit. The whole confusion comes from a big switch in India's arbitration law.
And this slide lays out the problem perfectly. You see, under the old 1940 law, it was crystal clear. The law explicitly said courts could modify or correct an award. But then, in 1996, a new act came along. It was designed to be more modern, to limit how much courts could interfere. And in this new law, that power to modify just vanished. The new act only talks about a court's power to set aside an award. It says nothing about modifying one. So the billion-dollar question became, does silence mean you can't do it? And that silence, well, it led to decades of total confusion. You had different benches of the exact same Supreme Court coming to completely opposite conclusions. It was a real mess.
This wasn't just some academic squabble. This created massive uncertainty for anyone using arbitration. If you won an award, you were constantly worried that a court might come in and mess with it. And if you lost, you didn't know whether to challenge the whole thing or just one part. It was a legal minefield.
So, in one corner of the ring, you have this viewpoint. This quote comes from a really influential case from 2021 called M. Hakim. And here, the Supreme Court took a super strict line. They basically said, nope, courts are not editors. Their only tool is a sledgehammer. Either approve the award as is or smash it completely and force everyone back to square one.
But here's the crazy part. Even though the Hakim ruling was so firm, other Supreme Court benches were doing the exact opposite. They were, in fact, modifying awards. Sometimes they tweak the interest rate. Other times, they'd chop off a part of an award that was bad, but keep the good parts. So you had this completely bizarre situation with conflicting rulings from the country's highest court. Nobody knew which precedent to follow. This chaos finally forced the issue. It had to be heard by a 5-judge Constitution bench, the big leagues, to settle the matter for good. So let's look at the arguments they heard. Okay, so on one side you had Team Modify. Their arguments were all about common sense and practicality. First, judicial efficiency. I mean, come on. Does it really make sense to force people through another multi-year arbitration just to fix one obvious mistake? Second, there's a legal idea that a greater power includes the lesser one. So if a court has the ultimate power to destroy the entire award, shouldn't it have the smaller power to just fix a part of it? And finally, it was about justice, preventing insane delays and costs.
But on the other side, Team Set Aside Only came with arguments based on core principles. They said, look, Parliament wrote the 1996 Act this way for a reason. It's based on an international standard that doesn't allow modification. Then there was the huge point about party autonomy. The whole reason people choose arbitration is to avoid having a judge second-guess the decision. And there was a big practical fear. If an Indian court modifies an award, other countries might not recognize it, making it impossible to enforce internationally.
So you have these two powerful competing ideas, pragmatism and efficiency on one side, and legal principle and the integrity of the whole system on the other. So how did the Supreme Court split the difference? Did they give courts a blank check to modify whatever they wanted, or did they stick to that strict set-aside-only rule? Well, the answer is neither. They carved out a really careful, really clever middle path. The whole thing boils down to one number, 4. If you remember one thing from this, remember the number 4. The Supreme Court said that while courts do not have a broad, unlimited power to modify awards, there are 4 very specific, very exceptional situations where they can. And here they are, the 4 exceptions. Number 1, severability. If part of the award is bad, but you can neatly slice it off without wrecking the rest of it, a court is allowed to do that. Number 2, obvious mistakes. Think typos, calculation errors, the simple stuff that doesn't need a whole new hearing. A court can fix those. 3, post-award interest.
The court decided it can adjust the interest that gets paid after the award is made. And finally, number 4, the Supreme Court's own superpower, Article 142, which lets it do complete justice. But they were very clear this should only be used in the absolute rarest of cases. So let's be super clear about this. The court did not throw the floodgates open. It very deliberately created a narrow, well-defined path for fixing certain problems, not a highway for judges to interfere whenever they feel like it. They upheld the basic spirit of the 1996 Act.
So what does all this mean in the real world? Well, it basically creates a new, much clearer rulebook for arbitration in India, and the impact is pretty significant.
A huge part of the court's reasoning comes back to this one idea: party autonomy. It's a fancy term for something simple: respecting the choice that people made. You chose arbitration for its speed and finality. You chose an expert arbitrator instead of a judge. The Supreme Court's decision respects that choice, while also building in a few safety valves for when things go wrong.
And the real-world result of all this? A huge boost in clarity and predictability. Now everyone knows the rules of the game. They know exactly when a court can step in and when it can't. And by allowing these small fixes, it makes the whole system more efficient, preventing everyone from having to start from scratch over a simple, fixable error. I absolutely love this quote from the judgment because it just perfectly sums up the new approach. A court isn't supposed to come in with a sledgehammer and just smash the award to pieces. Instead, its role is like a sculptor with a fine chisel, making very precise, very careful corrections only where they are absolutely necessary, preserving the original work. And that really leaves us with the big question. For decades, the system has swung between two extremes: a totally hands-off approach that could be unfair, and a hands-on approach that defeated the whole point of arbitration. Has the Supreme Court, with this new, limited power to chisel, finally found the perfect balance? I guess only time will tell. Thanks for joining us.